Charges have been filed in the Whitestown shooting case that resulted in the death of Maria Perez. Charges have been filed against Kurt Anderson, and in a little bit of an unusual move, the state of Indiana has filed voluntary manslaughter charges against him. So this video is going to explain what voluntary manslaughter is in the state of Indiana, what the term sudden heat is and why that matters in voluntary manslaughter charges, legally what Kurt Anderson is facing. We're also going to talk about why voluntary manslaughter makes sense in this case. And lastly, we're going to talk about why the prosecutor does not think stand your ground law applies here in this case. And the best part, I'm going to break it down in plain English. Under Indiana law, voluntary manslaughter is basically a murder that happens under sudden heat. Here's the statute. Voluntary manslaughter is knowingly or intentionally killing another human being while acting under sudden heat. The key to understand this is voluntary manslaughter is not a lesser killing. It's the same intentional act as murder. The only difference is the presence of sudden heat. The Indiana Supreme Court in Brantley v. State makes this crystal clear. Voluntary manslaughter requires a knowing killing, just like murder, but sudden heat mitigates it down from murder. So it's not an accident. It's not self-defense. It is an intentional act, but done while the person was overwhelmed with emotion. So that's voluntary manslaughter. The next question is, what is sudden heat? Sudden heat is the legal phrase that separates voluntary manslaughter from murder. Indiana courts define sudden heat as anger, rage, resentment, or terror sufficient to obscure the reason of an ordinary person. Let's unpack. Sudden heat exists when something provokes you, you react emotionally, your ability to think clearly disappears, and that emotional reaction causes the killing. It does not excuse the act, it explains it. Sudden heat is not a defense. It is a mitigating factor. This is important because a person acting in sudden heat is not acting reasonably. A person acting in self-defense must be acting reasonably. This is why the Indiana Supreme Court says the same evidence can support either sudden heat or self-defense, and it's ultimately the trier of fact, that's the jury, is their call to make. That's exactly what they said in Brantley. The same terror can either mitigate murder or excuse it altogether. This matters because the penalties are wildly different for murder versus voluntary manslaughter. With murder, a person is facing 45 to 65 years in jail with an advisory sentence of 55 years. Whereas voluntary manslaughter, a level 2 felony, it's a 10 to 30-year sentence with the advisory being 17 and a half years. So sudden heat can literally shave 15 to 35 years off of a sentence. That's why sudden heat becomes a huge issue in almost every single murder case, and it's why the charge in Kurt Anderson's case matters. Now, why does voluntary manslaughter make sense in this case? Let's look at the facts in the probable cause affidavit and the charging information. What do we know? According to the probable cause affidavit, at around 6:50 a.m. on November 5th, 2025, two members of a cleaning crew mistakenly went to Kurt Anderson's home. They were trying different keys in the front door, believing they were there to clean a model home. They were not forcing entry. There was no pounding. There was no yelling. No one's breaking the door down. Kurt never announced himself. Kurt never spoke through the closed door. Kurt did not issue any warnings. Kurt did retrieve his firearm. He loaded it, he chambered it around, and he fired one shot through a closed, locked door from the top of the stairs. The round struck and killed Maria Perez. The door was still locked and there was no forced entry whatsoever. The state then charged knowingly killing another human being while acting under sudden heat. Count 1. Why sudden heat? Because based on the affidavit, here is what the prosecutors likely believe. Kurt may have genuinely been terrified that someone was breaking it, but his reaction was unreasonable and emotionally driven. And because he fired through a closed door without confirming a threat, self-defense does not fit. But sudden heat still explains his terror. Remember, sudden heat means he was terrified, acted impulsively. Self-defense, he was terrified and reacted reasonably. This case appears to sit in that middle ground where the fear was real, but the response was not reasonable. So the law treats it as voluntary manslaughter, not murder. This makes the voluntary manslaughter charge legally consistent with the affidavit. Now, someone might be asking, well, why does stand your ground law not apply? He was in his home. They were outside the home. People see homeowner shoot someone at the door and immediately think stand your ground or castle doctrine. But Indiana's castle doctrine, part of stand your ground, requires an imminent threat of unlawful entry, a reasonable belief that deadly force is necessary, and an actual or an attempted unlawful entry. None of that is supported in the PC affidavit, and here's why. There's no unlawful entry. The door was locked. No one crossed the threshold. There's no force. There's no breaking. There's no kicking. This is specifically documented by crime scene investigators. Number 2, Kurt fired before confirming any threat. The affidavit says Kurt did not look downstairs, did not speak to the door, did not warn them, did not investigate, did not wait for any forced entry. Instead, he fired from a closed door from upstairs. And number 3, stand your ground requires a reasonable belief. Even if Kurt felt terrified, the law still requires the fear to be reasonable. You cannot rely on stand your ground if no one is entering, no one is breaking in, no one is threatening you. You don't even know who's at the door, but anybody at that door. Stand your ground is not a license to shoot anyone who accidentally turns the wrong doorknob. This is exactly the scenario sudden heat covers. Strong emotion, strong fear, but an unreasonable reaction. Now, remember, everyone is innocent until proven guilty, and this case is far from over. I know some of the attorneys involved, and I suspect they are going to wage a significant and strong self-defense argument to these charges. And self-defense still applies to voluntary manslaughter. They can still argue that, but that's the prosecutor already saying, we don't think that self-defense applies. We get why he might have thought that. So this case is far from over. Everyone's innocent until proven guilty. And this case is tragic from every single angle. A woman lost her life trying to do her job. A homeowner made a split-second decision under fear, but one the law considers unreasonable. Voluntary manslaughter is the middle ground for the state to choose here. We got tons of video on self-defense. Please watch them. If anybody is facing charges in the Great State of Indiana, give us a call, 317-632-3642. We have done lots of trials on self-defense. We've won lots of trials on self-defense. Give us a call if you're facing that situation. And most importantly, if you do have to make that decision to use self-defense, please get an attorney involved as soon as possible. I cannot stress that enough. Most importantly, remember to always plead the fifth.